would one have thought have been included in the legislation to enact the new Constitution? That would have been, I think, what most people would have expected to see, because it is removing references from the words of enactment to the Queen's Most Excellent Majesty and so on, and replacing them with language that makes no reference to the sovereign.
Welcome viewers and subscribers to Jadale Entertainment. Thank you for being here. All new viewers, click the subscribe button. Well guys, today in this video guys, we have Mark Golding expressing his thoughts and what he thinks about the constitution, right, and the changes that Andrew want to make on it. Right now he's basically saying that without the Queen permission, right, and now long live the Queen, you know, so she passed off. So guys, right now he's basically saying without the Governor General passed off this bill, Andrew don't have no talk about overseas citizen sitting in Parliament and becoming a Prime Minister of the country. So right now guys, without no further addition guys, we're jumping on the video so you guys can get to understand what Mr. Mark Golding is talking about. And the next thing guys, if you're new here, I'm asking you to stick a like on my video and please become a part of the family. Hit the subscribe button and hit the notification bell as well so you can be notified every time a video like this is dropped. Thank you.
Is to the Queen, but at the same time, for this bill to become law, the Governor General's assent is required under Section 60, and he will be giving that assent for and on behalf of Her Majesty. So you have this somewhat perplexing situation where the assenting to this bill is being done by the GG, the Governor General, for and on behalf of Her Majesty, or His Majesty now, to a bill which is removing references to Her Majesty from the words of enactment. I'm not sure why the minister wants to proceed with this as a precursor to the actual legislation to enact the new Constitution. I know that this has been a matter of some controversy or lack of consensus at the Constitutional Reform Committee itself because of the peculiarity of it. As the minister indicated, Section 34 of our Constitution says that the Parliament consists of Her Majesty, the British monarch, along with the House and the Senate. Section 68 says that executive authority is vested in Her Majesty. And both of those provisions are entrenched or deeply entrenched. And the establishment of the office of the Governor General, which is by Section 27 of the Constitution, states that the Governor General is appointed by the British monarch and holds office during the British monarch's pleasure. No bill can become law unless the Governor General has assented to it in His Majesty's name and on His Majesty's behalf. And the Governor General has to sign the bill as token of that assent, and that is what Section 60 requires. So one could see the concerns of many members of the Constitutional Reform Committee, including perhaps the most eminent constitutional lawyer in Jamaica, that the removal of words of enactment before even a bill to remove the King as the head of Parliament is even drafted is somewhat meaningless and even illogical. Quite apart from any technical question, now the minister has said that there's no issue of implied amendment in relation to this bill amending Section 61. She says it with great confidence, but the truth of the matter is the question of implied amendment, because it's not expressed in the words of the legislation, is ultimately a matter of interpretation for the court, which is not something that one can always predict with any certainty. But quite apart from any technical questions as to whether this amendment conforms with the constitutional restrictions on altering the Constitution, which are quite comprehensive and can operate by implication, the timing of this legislation is odd, even illogical, before the introduction or even the preparation of the bill for the removal of the monarchy. And we know that now that the report of the CRC has been made public, there's a lot of discussion about it in the public domain. There are many criticisms of aspects of it, and those need to be worked through a process of, I think, engagement and consultation with the public, so that when the legislation is prepared and comes to Parliament, it is not fraught with controversy at its inception. So I'm not going to oppose this bill, because obviously the change of the words of enactment to delete the reference to the British monarch is not something that anyone would object to in this House, I don't believe. But the timing of it is strange and, in a sense, illogical, because this very bill that is removing the references from the words of enactment to Her Queen's Most Excellent Majesty can only become law if the Governor-General gives his assent for and on behalf of that very same monarch. And that's a strange thing. The new Constitution itself, when approved, we hope, by referendum, if we get that far, will have to be assented to by the Governor-General as presumably his last act in that capacity, because the new president can only be appointed pursuant to the new Constitution when it has become law, and it can't become law until it's assented to by the existing Governor-General. But at least in that instance, in giving that assent for and on behalf of the monarch, he will be doing so on the instruction, so to speak, or the request of the people of Jamaica having approved the new Constitution in a referendum. And that, I think, is a palatable concept for us to imbibe. But to do it now, when there's no constitutional legislation before us in terms of the new Constitution, and when the assent has to be given for and on behalf of the monarch, it just seems very premature to me, and not only to me, but to others. And I think that the minister owes us an explanation, actually, as to exactly why this is being done now. I know she's going to speak in the sectoral debate soon and may want to have something on, to speak about then, but the reality is that many people find this a peculiar sequencing of events. And the fact of the matter is that the references to Her Majesty are strewn across the Constitution in many places, which this does not address. And the solution to those references are indeed in the Interpretation Act provision to which the minister referred, which says that any reference to a sovereign in the Constitution is to be deemed to be the sovereign for the time being. So that is the solution to that problem. So this is not an attempt, or cannot be conceived to be an attempt to solve that problem, because it only addresses the words of enactment and doesn't address the many other references to the sovereign in the Constitution. The solution is, in fact, and has been from the date of death of Queen Elizabeth II, the Interpretation Act provision to which the minister referred. So, Minister, I would ask that when you close the debate, could you please give us a very clear and coherent explanation as to why you're bringing this bill here now and not as part of the legislation when it finally comes here to introduce the new Constitution into our law. And that question, I think, is something which Jamaica would want to hear from you. And I don't think you've given that answer yet in your opening. Thank you, Madam Speaker.